This is Bloomberg Law with June Grasso from Bloomberg Radio.
We'll stop Donald Trump's extreme abortion bans because we trust women to make decisions about their own body and not have their government tell them what to do.
Presumptive Democratic presidential nominee Kamala Harris is making abortion rights a top issue in the November election, a familiar role for Harris, who's been the party's leading voice on abortion access. While Republican presidential nominee Donald Trump, who's generally shied away from the issue on the campaign trail, thanked the 6 conservative Supreme Court justices for overturning Roe at a rally in St. Cloud, Minnesota on Saturday.
Getting it back to the states puts the question where it belongs, with the vote of the people, and it's over time. And you'll see this over time. It's going to work out incredibly well.
But right now, legal battles over abortion are going on in courts across the country. Whether it's the continuing battles over the abortion pill, mifepristone, in federal courts, the battles over enforcing restrictions on abortion in state courts, now that 14 states have bans on abortion at all stages of pregnancy with limited exceptions, or battles in several states over abortion rights measures being on the ballot in November. Joining me is Michele Goodwin, a professor of constitutional law and global health policy at Georgetown Law. So let's start with the battles over the abortion pill. The Ninth Circuit shot down last week a request by Idaho and 6 other Republican-led states to get involved in this lawsuit between Democratic-led jurisdictions and the Biden administration over the abortion pill mifepristone. What exactly is this suit about?
Well, essentially what you have is that the state of Washington believes that the FDA has been too restrictive with regard to mifepristone and that some of those restrictions need to be lifted. There is an argument to be made for why the state of Washington has pushed forward this litigation. Before mifepristone had been approved in the U.S. marketplace, it was already in use in other parts of the world, had been deemed to be safe and effective, and we know through 24 years of mifepristone being available in the United States that it's been widely used, certainly even more so post the Dobbs decision, but that it's safe and effective. All of the research consistently shows that. And so the state of Washington has suggested that essentially by denying a broader berth for the use of mifepristone, it's denying greater access to people who could benefit from using that. The intervention that's been led by states that have abortion bans or conservative legislatures is, in effect, to tamp down on that. They've been denied, Idaho was denied the opportunity to basically intervene. And that intervention would have essentially been part of a broader movement, which is to restrict mifepristone in the U.S. marketplace.
So it was, again, an issue of standing, much as the mifepristone case at the Supreme Court was. Explain why the judges decided that those Republican states did not have standing.
Well, in order to have standing, you must actually be affected by it, and you must have what one would call some skin in the game with regard to this and be harmed, and the potential that you could actually get relief, the kind of relief that's being sought. And what you've seen recently in these abortion cases is that the way to dispense with them is on technical procedural grounds rather than the substantive argument. And so in this case, Idaho and others, they don't have the standing in order to be able to intervene. In this case, it's a procedural way of essentially shutting them out.
At the same time, there's a battle over mifepristone in the Northern District of Texas, and this is the case that went up to the Supreme Court that found the physicians group didn't have standing to sue. But Judge Matthew Kaczmarek, who I will say is a Christian ideologue, he's allowed Idaho, Missouri, and Kansas to take up where the physicians group left off. How did he find that those states had standing?
So this is a really important question, and the question gets at the heart of what we've seen in this space. Years ago, Erwin Chemerinsky, who's the dean of the University of California, Berkeley Law School, and I wrote an article about gerrymandering abortion rights. And that's where I'd like to start with answering this question, which is that if one actually assumes that there is some legitimacy here, then one tries to find the answer that is clear and that is logical in order to be able to respond. But unfortunately, what one sees in cases that involve abortion rights has been what some might call selective outcomes, outcome determinism, or even opportunistic originalism, which I've called some of these decisions. And that is to say that it's actually hard to find the legitimate theory, the legitimate rule of law argument, the legitimate, well-articulated beyond those judges, an argument that lines up. That's been very difficult, and yet what we found with Judge Kaczmarek, well, two things I think that are worth noting. With Judge Kaczmarek, he's the lone sitting judge in Amarillo, Texas, so there has been a kind of forum shopping or judge shopping, some have articulated, with regard to Judge Kaczmarek and some others, where they know that there is a particular outcome that might almost be guaranteed given the ideological and political leanings of those judges. I think it's worth noting the distinction between what would be ideological and what would be political that we've seen in very recent years. And so in the space of that, with Judge Kaczmarek being very outspoken in terms of his anti-abortion views, his anti-abortion writings, etc., that even though the Supreme Court had ruled that the plaintiffs in the mifepristone case, where he had basically provided for this alliance all that they had requested, basically wrote an opinion in that decision that was very generous towards their interests. The Supreme Court ruled that this particular group, which fashioned themselves as doctors, but one was a dentist, another one a master's degree in theology, the court ruled that they did not have standing. The Supreme Court did. Now, with your question about this new crop of individuals, I preface it by just simply saying that Judge Kaczmarek has shown himself to be outcome determinative. He relied in the mifepristone case on an anonymous blog post. He relied on and cited two articles that were later rescinded because of their dramatic inaccuracies. And so we're not talking about a judge that has shown the capacity for looking objectively at matters with regard to abortion, and that includes with how he's handled matters of standing.
The lawsuit's going forward in Texas, then, with these Republican states as the plaintiffs?
For now, that is what's taking shape. And let me just add one additional thing to this, which is that the Supreme Court itself gave an open door for the possibility that there could be other plaintiffs that might be able to pursue this line of argumentation. So even while the Supreme Court ruled that the plaintiffs who were part of the Hippocratic Alliance did not have standing, the court yet offered other kinds of analysis where there could be others that would perhaps be able to pursue this line of limiting mifepristone in the marketplace.
Let's say Kaczmarek's decision goes up to the Fifth Circuit, which I assume it will at some point, and the Fifth Circuit finds that these states have standing, these Republican-led states. That is contrary to the Ninth Circuit's ruling. So then this issue goes back up to the Supreme Court.
Yeah, so the Fifth Circuit has shown itself to also be one of the most conservative in a political fashion, not just ideological. You know, over centuries, there are justices that have ideological leanings. There's been some room for accepting that their ideological leanings may be infused in how they observe, analyze, write an opinion about a case. But I think it's important to note that what federal judges, scholars, and others are noticing is that we're in a space that's far beyond ideology where there's seemingly a political agenda amongst some judges and even justices. The Fifth Circuit has been called out in that regard for taking extreme views that are extreme departures for what has been American rule of law. And it would not be surprising if it were that Judge Kaczmarek, who failed in the first mifepristone case, and that failure was in not recognizing that those individuals did not qualify for standing, for which he was corrected at the Supreme Court level, right? So that was a failure that was corrected by the Supreme Court. But it was a failure that was not caught by the Fifth Circuit, an argument being that this is a Fifth Circuit that has also deeply political views, and those are deeply conservative political views that one might say align with a judge like Judge Kaczmarek. So if there is a conflict between the Ninth Circuit and the Fifth Circuit, those are usually matters that are resolved by the Supreme Court. Now, it's not as if it would be new where there are circuits that are in disagreement and the court doesn't take them up right away, right? That's taken place before. But on an issue like abortion, which has so captivated this country politically and otherwise, there's stories about women who are struggling, who had miscarriages that needed to be managed and were near death, has really captured the public imagination. And so with that, it would not be surprising that the Supreme Court would grant cert to resolve this issue.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Georgetown Law professor Michele Goodwin. We'll talk about the legal battles over those ballot measures getting on state ballots in November. I'm June Grasso, and you're listening to Bloomberg. I've been talking to Professor Michele Goodwin of Georgetown Law about the legal battles over abortion. Michele, as far as the cases over mifepristone, the abortion pill, part of the attack is that the FDA, according to the conservatives who are suing, hasn't done the right risk evaluation and mitigation strategies on mifepristone. So, the approval process, et cetera, is being attacked. Could the FDA go through the approval process again and deal with all these things that are being brought up?
That's a really good question. And what your question surfaces is something that one saw with trap laws. So the targeted regulations of abortion providers, when I was writing about these issues, a decade ago, right, as being the flashpoints that one needed to pay attention to because, being able to see what was coming up the pipeline. Well, this is much like that. Part of the point of trap laws was, in fact, an attempt to constrain access to reproductive health care, such as abortion. But what it also did is that it meant that well-established law and people who supported well-established law, be it agencies, advocacy organizations, had to begin spinning their wheels and spending money in order to respond to these targeted regulations of abortion providers. And what one sees in the space of this is that even if there are failures, if it gets the FDA and organizations having to utilize resources and fight, then that also then exhausts other ways in which they might promote health care or promote health advocacy within the reproductive landscape. So for the FDA to go back would be unheard of. I mean, typically that doesn't happen. It doesn't happen with a drug that's already been proven to be safe and effective. There aren't claims outside of groups that are anti-abortion that mifepristone is unsafe, ineffective, and that it was rushed to the marketplace. There has been literally, tens of thousands of people who've used mifepristone. There is no sort of collection of litigants who've used it, who said that they were, harmed by this, and the FDA should have known, right? That just doesn't exist. And it's also very interesting, too, another point when you think about this, that to the extent that there are those that are arguing that it is unsafe and effective, are a lot of people who do not have uteruses, right? So, which is just as a point, right? So typically when there's, litigation, you're able to bring forward, here's this mass litigation. This was rushed to the marketplace. Look at all of these people who were harmed by it, whose futures were undermined by it. in healthcare, there's the willingness to accept the randomness of people who may be harmed, and we protect against that at the federal, level. For example, with vaccines, right? There are shield laws that recognize that not all people will respond to vaccines as the vast majority will, right? But we don't take vaccines off the marketplace like polio and whatnot because there is the very isolated random person that is negatively impacted. And the same would apply to a drug like mifepristone or any other drug. We don't take them off the marketplace because there is that sort of random, isolated one person who is negatively impacted by it.
Let's turn to the abortion rights ballot measures. So I counted definitely on the ballot abortion rights measures in 5 states, Colorado, Florida, Maryland, Nevada, and South Dakota. And signatures have been submitted and awaiting approval in Arizona, Montana, Missouri, and Nebraska. And there are disputes over these ballot measures in some states. In Arizona, there's a dispute over how to describe the measure. A Republican-led legislative committee wants to describe a fetus as an unborn human being, and that's being opposed by abortion rights groups. This also happened in Florida. It's an attempt to use language to sort of prejudice or confuse the abortion issue.
Well, we've seen that contestation in Ohio as well. We saw aspects of that in Michigan. So there is an argument that there has been manipulation and coercion, and that is to say that voters should be able to determine how they feel about these issues based on what happens to be basic scientific factual information and not be misled by the narratives that have been put forward, including ones of saying that fetuses are unborn children and various other ways. In Ohio, and Michigan, there are a number of other ways in which there were state officials who sought to undermine the clarity of what was actually on the ballot initiative. And I think that there is a broader issue to consider in that regard, and that is that despite the fact that the Supreme Court in the Dobbs decision said that these would be matters that would be left to states and their voters, it's not. There's been a deep level of political coercion in trying to limit voters' access to be able to engage in the political process in these ballot initiatives. So when these ballot initiatives are not just simple, clean, clear scientific health information, but instead are saddled with innuendo, it strikes against what was the principle articulated in Dobbs that voters get to decide. And these are state-level matters, and in some ways it ties a voter's hand behind her back, where then she has to study and look at the ballot initiatives more closely, look up information to make sure that what it is that's being voted on, follows the values and interests that she has, no matter which way he or she, or they happen to be voting. It's become far more complicated. And of course, in Ohio, what we saw were efforts to even change the way in which ballot initiatives go forward, such as increasing the percentage that would be necessary in order for a ballot initiative to be able to prevail. And all of this around the matter with regard to abortion.
A similar thing is happening in Montana, where the Secretary of State was sued over changes she made to the rules about whose signatures can be accepted to support ballot measures. And last Tuesday, the Montana Supreme Court basically overruled her. And in Arkansas, the Secretary of State rejected the signatures that were submitted for a ballot measure, and that's headed to court. It seems like the greatest challenge might just be in getting the abortion rights measures on the ballot when they're being undermined by election officials.
That's right, which also says something very important about where Americans have to pay attention. And I think Americans are beginning to recognize how important it is, the role election officials have in state government. The anti-abortion movement has been quite thoughtful and sophisticated with how they've chosen to address the reshaping of American discourse, American law, and the rule of law with regard to abortion and also other issues. That is to say, that there's been very close attention paid to school boards. There's been very close attention paid to states' attorney generals, to secretaries of state, and also then to election officials within states. And then also, local city councils and whatnot. Basically, no stone unturned from a movement that seeks to solidify complete resistance to abortion rights, and complete resistance that's not always in objective and fair ways, complete resistance in ways that may also be undermining, which has been what some of these state Supreme Courts have responded to, seeing the lack of legitimacy in the way in which there have been efforts to undermine voters being able to have a clear and clean access not only to casting a vote, but to know what they are casting a vote about.
I take it's because all of these abortion-related measures, it was 7 ballot questions in the last 2 years, they passed. So It's a fear, I take it, that if the voters actually confront the issue, they'll approve abortion rights.
That is the real concern. And consistently what one has seen in these ballot initiatives, and I think that's why this is so alarming in the efforts to try to undermine this political effort, is because even in states where there are conservative legislatures, there has been the rejection of ballot initiatives that would instantiate, let's say, personhood in the state's constitution in order to prevent people in that state from ever being able to have abortion access. We saw that in the state of Kentucky. Alternatively, what we've seen is that in states that have blue legislatures or Democratic governors, or ones where the legislature is a bit mixed, such in the state of Michigan, for example, you've seen very successful ballot initiatives, and in Ohio, successful ballot initiatives that defend the constitutional right to be able to terminate a pregnancy. There are a couple things that one can see in the space of all of this. When the Supreme Court overturned Roe v. Wade and Planned Parenthood v. Casey, they did so despite the fact that consistently with polling, most Americans support abortion rights in the United States. They support contraceptive access. And since the Dobbs decision, that support has intensified, particularly given that Americans have seen how draconian the enforcement of anti-abortion measures happen to be, how cruel they happen to be, such that even in cases where women are near death, on death's door, there's basically been the concern that they have not been able to receive the medical care in those states that they need. So we see that in Idaho, where there have been doctors that have helicoptered women out of the state in order to get the health care that they need. In the state of Texas, even after Kate Cox and her doctor were successful in getting a district court judge to agree that the state's exception should apply to Kate Cox, such that she should be able to get an abortion in the state of Texas, you have both the state's attorney general and the state Supreme Court saying, well, that doesn't apply. Kate Cox isn't the ideal person who would qualify for the exception. And you had the state's attorney general going so far as to contact doctors and hospitals, threatening them with punishment, civil, criminal, et cetera, if they were to go forward and provide the relief that Kate Cox needed, which a lower court judge said that she deserved to have.
The litigation will continue, and we'll see whether abortion rights measures can get on the ballot in some of the states that we talked about: Arizona, Arkansas, Montana, Missouri, and Nebraska so far. Thanks so much for being on the show, Michele. That's Professor Michele Goodwin of Georgetown Law. Coming up next on the Bloomberg Law Show, we're down to the finish line in the race for President Biden to catch former President Trump in the number of judicial appointments. I'm June Grasso, and you're listening to Bloomberg. In one term as president, Donald Trump appointed 234 judges, well below the totals of recent two-term presidents, including Barack Obama, George W. Bush, and Bill Clinton. And as far as appellate courts, Trump flipped the balance of several appeals courts from a majority of Democratic appointees to a majority of Republican appointees. President Joe Biden is in a race to equal or beat the number of judges appointed by Trump. The Senate has confirmed 202 judges nominated by Biden, and it's the home stretch. Joining me is an expert in the federal judiciary, Carl Tobias, a professor at the University of Richmond Law School. Carl, Biden has appointed 43 judges to the appellate courts. How does that compare to Trump's number?
Well, Trump ended up with 54. And if you remember back in 2015-16, the GOP majority in the Senate only confirmed 2 of Obama's nominees in those 2 years. And so there were many vacancies available for Trump, and he filled them quite quickly once he was elected. And so that explains it. There just haven't been that many vacancies available. But there are more nominees, too. There are 4 or 5 who are waiting votes, mostly on the floor. One may have a hearing this week. And so I expect that Biden will come close to Trump's 54, but maybe not many more than that, and probably lucky to get to that point, because there are about 6 or 7 vacancies now. But I don't foresee very many people taking senior status, for example, until after the election, if at all. And so there may not be opportunities coming up. And, of course, there's a very truncated Senate schedule moving forward. They go out this week and then stay out till the week after Labor Day, and then come and work 3 weeks, and then go to campaign until the elections. And then there's a lame duck starting on November 12, I believe.
So you think during the lame duck they can get some things done?
Absolutely. I mean, I think they intend to have hearings and to move people out of committee to the floor and have cloture and confirmation votes all the way till the holidays in late December. That's my understanding, and Thanksgiving is the only break they'll have then. And so there are a number of weeks there, and there are many people on the floor right now waiting for cloture and confirmation votes, a dozen or more, and there will be more. There's a hearing this Wednesday. So they're determined to move them. They just won't have a lot of working days when they get back from the break for August.
A Bloomberg law analysis shows that more than half of Biden's federal appellate court appointments so far were in their 40s or younger when they joined the bench. Is this about cementing your legacy versus having more experienced judges on the bench?
Yes, and I think presidents of both parties have done that really for a long time now, both Democratic and Republican. If you think back to Bush or even to Reagan, Clinton is, I think, the person who thought that it was a capstone to your career to appoint someone to the federal bench. But I think that presidents in this century have been much more inclined to move to younger and younger people. Trump certainly did that. I think he had people in their 30s on the appeals courts. And Biden, though, has followed that, and many people in their 40s and some in their 50s, but hardly any, older than that.
Former Judge Paul Watford, who was 44 when he joined the Ninth Circuit, said, "I don't see anything good that comes from nominating people to the bench at a very young age, to be frank with you." Also, several judges who were nominated when they were young have stepped down to join law firms. And so they don't stay on the bench as long as you might think.
That's true. I mean, that has happened. And I'm thinking of some like Greg Costa on the Fifth Circuit and Watford. And that's unfortunate. But they certainly would be paid a lot more and might like the work more than, for example, Costa dissenting on the Fifth Circuit, and not much opportunity to change the composition of that court because so many ideologically conservative people were nominated and confirmed by Trump. So it's to be expected, I suppose, but it's unfortunate. And so you may see that trend as well. I think there have been a number of district judges, too. I'm thinking one in New Jersey, who only stayed on 6 years just because he thought that there were better opportunities for him in the private sector.
It's also been pointed out that when you're younger as a trial judge, a district court judge, and you don't have that much experience, it can be more obvious than if you're on appellate bench where you're sitting with at least two other people. And I can think recently of Judge Eileen Cannon in Florida, a Trump appointee, who was in her late 30s, and her handling of the classified documents case has drawn all kinds of criticism.
Yes, I think it's difficult, and it's unfortunate that her colleagues didn't help her. And I think she was pretty isolated in Fort Pierce. You know, and even the chief judge apparently suggested that this might be a tough case for her to handle. But it's different, you know, than, say, in Miami, where you have 20 or 25 judges. And I think there's more consultation, there's more collegiality, there are more people to talk with, and all of that. And so I think it is hard. And, you know, you get a big caseload. I mean, remember that Maldonado, who was on the Northern District of Illinois, 3 judges retired from that court, and they dumped 300 cases on her. That's tough, just to have to handle that kind of docket. But that often happens. I talked to some judges, you know, who are like the most recent appointees in various districts, and you know, they get the least desirable cases sometimes. And so it's tricky.
Also, another younger judge was Joshua Kindred, who stepped down from the Alaska district because of that sex scandal. So now that leaves just one judge in Alaska right now. Are they going to be able to fill those?
The saving grace there is the senior judges. I believe there are 3 or 4 working with the one active judge who also is a chief judge. So I think the senators need to work together, and I hope they're doing that. But certainly Murkowski has been pretty vocal that this needs to happen. But whether it'll happen soon, I'm not positive. I know the White House would be happy to work with them and find some fine people to help the courts. But it's tough. Though the seniors, I think there are 3 or 4 very experienced and well-respected senior judges, but I think 2 of them are in their 80s in Alaska. So that makes it tough as well.
Donald Trump really appointed a lot of ideologues, you know, who were blatantly conservative. Has Biden done the same thing with his judges? Has there been a focus on the ideological outlook more than there was years ago?
I don't think so. I don't think as much. I mean, I think what his goal has been is diversity, but principally experiential diversity. We've talked about that before. Many more people who did criminal defense work than prosecutors. And the tradition was, as you know, forever, that most of the people were former prosecutors in the federal or state systems or from big law firms. And Biden has changed that. More people who've done plaintiff side work, more people who do employee side labor work, more legal aid lawyers, more civil rights lawyers. And I think that's the hallmark of his appointees, as well as ethnic, gender, and sexual orientation diversity. But I think partly the administration may believe that a number of people who do that type of work have different ideological views than, say, some Trump appointees. And don't forget, the Fifth Circuit has been reversed a number of times by the Supreme Court in the most recent terms, just because some of their opinions are just too far even for the Supreme Court, I think. They didn't have a very good record this year. And, you know, the abortion pill case is a good example.
Do you have any idea how Harris might approach this? Similar to Biden? Different? What do you think?
Well, I think she will take on the same kinds of emphases that Biden has pursued, experiential diversity and other forms of diversity. And in her time on the Judiciary Committee, she was a quite active member and a very strong member. And you might remember her questioning of Justice Kavanaugh at his hearing was very vigorous and rigorous and tough. And so that was my general sense of her as a tough former prosecutor on the Judiciary Committee, asking hard questions of especially Trump nominees, because she served on that committee during, I think, his whole tenure. And so I think she really understands that, and she understands the federal courts. And so that's all very valuable. And I think she'll be good, and I think a number of the people in the White House are still there working on judicial selection. And so if she's elected, she, I think, would probably call on a number of those same people who have done excellent work so far.
Of course, if Trump wins, we already know what kinds of judges he'll be appointing. Thanks so much, Carl. That's Professor Carl Tobias of the University of Richmond Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.